Thanks so much, and thanks to Cato for pulling this together, and thanks for all the work that staff is doing both here in the Senate and in the House to move this issue forward, including making space available for us today. I actually see a lot of people who I've talked to already who are invested in this effort, and I'm really excited to see it moving forward. Google is definitely a proud member of the coalition, the Digital Due Process Coalition. Greg will speak more to what that coalition has been up to. It's been led by CDT. I'm going to talk a little bit about, first, get into some of the changes in technology that Julian discussed, and specifically how Google sees some of these changes in our products, and then also talk a little bit about the problems that the outdated rules in ECPA present for Google on an operational basis. As I said, I'm going to show you a couple of things to break up the monotony a little bit, and I'll hold off on that to the end because I've got to connect all the AV equipment at the end. And that will segue perfectly into Greg's speech, because we'll have a little video about digital due process. So first, let's talk about technology. And a stat that really gets to me, and this is similar to what Julian was talking about, the stat that really gets me is in 1986, a 10 megabyte hard drive cost about $650, and that would store about 2 high-resolution photos. Now you can go out and buy for $99 a 1.5 terabyte hard drive, and that would store about 300,000 photos. That same exponential change is reflected also in processing. It's reflected in transfer rates. It really has revolutionized our expectation of how we interact with data, what data we should have available to us, and how we produce data. And let's be clear that while this poses some risks that we're talking about here in terms of privacy, it's also delivered enormous value for all of us. And we're not looking back. I think we're actually moving forward, and these trends are only going to continue. We've seen enormous benefits to all of us from this increases in processing and data transfer and data storage. So let me take a look at 3 services Google offers and really show you how they don't map well to where ECPA was when it was drafted in the technology in 1986. We offer a webmail service called Gmail. It's got tens of millions of users. It's one of the first Google products I really fell in love with. I started using it back in 2004, and since I've started using it, I've actually only used 15% of my storage allotment of 7 gigabytes and growing. And I've never deleted, with the exception of some spam, I've never deleted a single email. And that's the point of Gmail. Never delete. Archive everything, have a searchable index of your email that you can access from anywhere, for any purpose you want, forever. There's been a sea change in the way that we see email. Now, the thing is, at least email existed in 1986. We have other products that really have no parallel at all to the technology that existed then. Take Latitude. Latitude is a location sharing service. It's available. People walk around with their mobile phones, and my colleagues are annoyed that I still carry around the Apple device, but I love my iPhone. And I have Latitude on it, and I can share my location with my friends, and my friends can share their location with me in a private network. It shows where I am at any given time at a level of specificity I want. Compare this to 1986, where 340,000 people in the entire United States had anything resembling a mobile communications device, and that was for voice communications on analog. Not a single one of those people could send a text message, let alone access any kind of internet service. Also, I wanted to focus on Docs. Docs is our online word processing system. Again, word processing existed. I don't know if any of you were using word processing systems in 1986, but you probably had your IBM 286 or something along those lines. And you could write up a document and print it out. It was stored on your home computer. Docs is a completely cloud-based word processing system. It allows you to collaboratively, in real time, work on documents with other people located anywhere else in the world as long as you have an internet connection. This bears very little resemblance to, the closest analogy would be a remote computing service in ECPA, but this is not what remote computing service was at the time. I think Julian spoke to that a little bit, but we were talking in 1986 about batch business processing of the kind that large entities would need to do because they couldn't afford to have the Cray computer or whatever it was that could chunk that through that amount of data. They couldn't afford to have that in-house, and they would outsource it. This looks nothing like that. The documents exist only in the cloud. People rarely download them, if ever, and they access them from anywhere and use them with multiple users in an environment that they consider private. Keep keep the idea that docs is only in the remote system, that it can be accessed and edited over time. I'm going to return to that and talking about some of the problems that we face when interpreting ECPA. So how does Google look at ECPA and what problems would we face? So I think basically we sum it up by saying ECPA is difficult to explain to our users and it's difficult for us to apply. And this confusion and the cost associated with it really for us is undermining the growth of our services and the growth of the cloud. Cloud services, internet services, and we're really concerned about that. Our users, when they look at ECPA, if they take a look at the procedural steps that Julian walked through that are in ECPA's language, they don't understand them. They don't make sense. I don't think they reflect their reasonable expectation of privacy. I think if you ask almost any internet user, they would say that the email that they use is just as private to them as their communications on a phone or the postage mail that they send or a conversation that they have in person. Some have asked, why is there then no major outcry? I think the reason is most users don't understand this. And I think they don't know what the rules are, and they don't understand that there's a different procedural level depending on what service they're using and how they're using it. But this is actually a very common complaint amongst our enterprise customers. We hear this a lot. People say, well, we're interested in moving to the cloud, but we're not sure how this is going to work with when you get a request for our records from some compelled records, whether in civil litigation, in criminal litigation, or in some other means. How are you going to deal that? Tell us. And we walk them through, we explain to them, and many of them, even sophisticated business customers, don't know what the standards are for access to their records. Take, for example, a news publishing company. There still are some around. And news publishing companies have an enormous amount of interest in protecting their sources, for instance, and their private communications. And when they host those on their own servers under their own control, they know that if they get a request that they don't feel respects their First Amendment rights, that's compliant with the law that, as they view it, they can go to their counsel, they can contest that, they can negotiate that with the government officials on their own. When a provider, an outside provider, has that information, they're going to have to trust what we're going to be doing with their data as opposed to themselves. And not only trust what we're doing with the data, but trust that the standards in ECPA, which would be lower than the standards that they would deal with for their own information, are going to satisfy their needs. And that's a big issue for us. And we've seen it from our customers, and we know that other members of the Digital Due Process Coalition have complained about similar problems when they try to grow their own cloud services. This problem is part of why we developed our government request transparency tool. I'm going to demo that in just a minute. But we are trying to bring some clarity to a process that has not had very much clarity in the past. So we think that this is really going to move the ball forward to say to users, not just in the United States, but worldwide, here's what Google is doing when we interact with governments who are requesting information about you or from you. And you should see that. You should have some clarity into that. We hope other companies will follow suit. And that way you can actually have an educated dialogue on this. And I think until that happens, it's really going to be a struggle to explain to people what the need is for a change in the law. So the second part of the problem that we face with ECPA is the fact that it is murky and difficult for Google to apply. Holding aside any civil liberties concern of any kind, it's simply a cost burden for us to figure out how to comply with it, what the standards are, whether a request is valid or not. And the confusion that comes out of this breeds both waste and risk. It breeds waste in the resources that we have to spend interpreting it, that the resources that law enforcement and others have to spend trying to convince us about their interpretation of the standards. And it provides risk to us that we might get it wrong, a risk to law enforcement that they might have the wrong interpretation. And I want to first point out here that almost all of the requests that we get from law enforcement are absolutely valid, and not only valid, but extremely important in tracking down really bad actors. Just as we've moved our lives online, criminals have moved online as well. And 99.9% or more of the interactions that we have in law enforcement are fit that mold, and we are happy to be a partner with law enforcement in doing that, and we want to continue that. We feel like we've had good interactions, we want to continue them, and that's at all levels, not only from the federal level, but all the way down to local law enforcement as well. But ensuring that we get the answers right in complying with these processes, and when you see the government request tool, you'll see some of the numbers we're talking about, it requires us to have a dedicated expert team that does nothing except for receive, process, and interpret these requests to ensure that they are valid, to make sure that they comport with our view of the letter and the spirit of the law. And sometimes it's a hard call. Sometimes we differ with law enforcement's view. Take docs as an example. I don't think any court has ruled on the issue of what happens when you have a doc in the cloud that is edited over time. So you have a 180-day rule where, for instance, for a communication would drop from a warrant standard to a lower standard. A warrant, actually, that's even a contested aspect of the law. It would drop from down to a subpoena standard after 180 days under a theory. I think Greg will explain a little bit about how we would change that aspect. But it would drop down to a subpoena standard for access to email older than, communications older than 6 months. But if you have a document that's edited in real time over time, how do you declare what that date is? Is it the date that the document was uploaded? Is it the last edit date? Is it the last viewed date? And speaking of which, how do you figure out when it was last viewed? Because under the DOJ's interpretation of ECPA, the time at which a communication was viewed changes its procedural, the procedural access standard. Docs presents really tough problems, and these are problems I think that we want to work through with law enforcement when we have them, but we would like some clarity to the law so we know how to exactly deal with this. Holding aside any civil liberties issue, we just want to know what standard we need to apply when we have a request for this information. I want to point one example that actually brings this into some clear light. Yahoo recently faced a request right along these lines. They had a request from the DOJ for email of subscribers that was less than 180 days old but had been viewed by the recipient of the email. And they used less than a warrant standard to request that information, and Yahoo contested that in court. And actually in an amicus brief joined by both CDT and by Google and many of the other members of the Digital Due Process Coalition, we suggested that was actually not a proper reading of ECPA and not a proper reading of the Fourth Amendment as well. The DOJ retracted their request and has sought other means to get the same information. And while we think that's the right outcome in that case, it took over a year. It involved lots of lawyers. It involved lots of time. It was the time of the providers. It was the time of DOJ prosecutors and officials that could be better served going after bad guys. It also took the court's time. That's time that we'd rather have and resources that we would rather have spending on doing the actual work of all of our parties. And part of that interpretation was whether the Ninth Circuit interpretation of what a email and electronic storage is, whether that should be applied more broadly. That's an interesting question, and I think the Ninth Circuit got to the right answer there, but I don't think even Judge Kaczynski could tell you what expires in the normal course actually means. It's a question, if we ever get a chance to ask him, I'd like to ask him. So not only are these disputes a waste of provider and law enforcement and court resources, they're also very risky. If a provider grants access under what turns out to be an improper view of the statute, they face litigation and potential penalties. If it denies a request that it should grant, it could not only poison the relationship with law enforcement, but it could let a criminal perhaps escape or impede an investigation. None of those outcomes are ideal, and we want a solution that's going to be allowed a more clear and consistent interpretation of ECPA.